Welcome back. Here's the wrap-up on the case involving Grayson Bay before Judge Perkins. Yesterday, Bay was found guilty on most counts. A jury trial on the final 2 charges was set for today. That trial never happened. The prosecutor dismissed the last 2 counts, so there was nothing left for a jury to decide. With that change, the court moved straight to sentencing on the convictions already retained. Judge Perkins addressed the defendant directly, offered a firm reminder about courtroom rules, and then announced the sentence tied to those guilty findings. That's the timeline. Convictions yesterday, remaining charges dropped today, and sentencing delivered by the bench. Let's break down what the court decided and what it means next.
Versus Javar Tyrone Grayson, case number SP14643761, SP14640991, SP146390, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Good morning, Your Honor. Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to get the record straight from yesterday. I did mention, and you did cite. Where's Mr. Grayson Bay's file? Yes, but I brought it back downstairs. Yes. I wanted to clear up something I said on the record as far as the case that you cited out of Alabama. That I was incorrect as far as the facts of that case.
For anyone who has used so-called sovereign citizen arguments, here's a clear example of acknowledging an error and taking steps to correct it.
That was not the case where they were walking down the street and did not obtain the license to assemble. That was a case where he has another reverend organized a sit-in and at a restaurant, and they were ticketed. And the unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing cases, sir, that you're not even reading.
I actually welcome it when self-described sovereign citizen defendants cite case law. It sends me back to the sources and sharpens my understanding of how the system works. But in practice, those citations often only resemble the facts at hand, and just as often they point to conclusions that are the opposite of what's being claimed. Put simply, if you're going to rely on precedent, make sure the case truly matches your situation and clearly supports your position, or you risk weakening your own argument.
I can actually fine you. That's something a lawyer would be could be brought up to the grievance commission on and potentially lose their license. All the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a duck, it acts like a duck, it tells you it's a duck, it's pretty much a duck. So I'm more science. So I've been studying for over 10 years.
That line caught my attention because I repeat it often. If a claim looks and sounds like a classic sovereign citizen argument, courts will treat it that way. The label doesn't change the substance. Whether someone identifies as a Moorish Science adherent or an American state national, if they argue they can drive without a license or that the court lacks jurisdiction over them, it fits the same pattern. In practice, judges focus on the legal claim, not the name, and these arguments are routinely rejected.
And
But you haven't been studying.
no disrespect to you, Your Honor. I just want to remain mute to the fact and acknowledge that my mother is here, the matriarch of my family, and so I just want to remain mute to this case in this matter. And the floor is yours. This is your courtroom. No disrespect. My mother is here.
No. Ma'am, can you stand up and state your name, please?
My name is Mary Grayson Hall.
Good morning, Ms. Grayson Hall. And it's nothing about, you can see it. I just wanted you to acknowledge, I do acknowledge the fact, and I appreciate the fact that you have support here. The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now. But you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have applied, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads, you don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over. Is that correct?
Again, Your Honor.
At this point, the smartest move is to stay silent. You've acknowledged your right to remain silent. The real question is whether you can actually use it and hold your tongue now.
With due respect to the court, my matriarch is here, and I gave you pretty much documents to read, and I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901, expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP 1463903, insurance no proof, and I say guilty on SP 1464091, and that's $240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had in the note. Well, you told me off the record that you're going to dismiss SP 146436761 and SP 146390002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I would probably need after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
They lined up. They're not completed. They're just future jobs.
You've said there are opportunities lined up, but there's no sign of confirmed work. In most major cities, jobs are available. The next step is committing to the search, applying, and following through.
Today, I'm not in court.
You got this play on words.
Yeah, I mean, traveling and
Is this
driving. Yeah, it beats the system. Play on word. I mean, it's the truth, though. I mean, I got to speak the truth to you, right?
You're
respect
not
the truth?
working now. If you,
Okay, I'm not working today. I'm not working.
No. You're not. I'm asking you, why is it taking you 3 months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3 months.
Because you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter, and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Well,
I'm going to work tomorrow, and I'm going to work the next day.
Yeah.
So I'm not giving you 3 months.
Very optimistic. That's why I say, well, as this present, not, but yeah, tomorrow. I'm very optimistic about work. So yeah,
So you're not working.
today I'm not working. Tomorrow I'm going, I have grass work tomorrow to do. There are schedules to do, and I do have a future as a job to have things to be done. But as you saying, as I'm working, I'm telling you the truth, not as now, no. If that clears, if that makes you feel comfortable, no, I'm not working.
I'm trying to ascertain.
No, I'm not working.
On,
I'm not working. At this present moment, I'm not working.
And when you say you're working, you have some aspirations of
Yes.
working, like everybody does. We're looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So you're not working now, correct?
Right. Thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need any mental health services? Do you?
I'm concerned because when someone adopts this path and shows they don't understand the law or the court process, a competency review can be appropriate. It protects their rights and ensures they can participate and make informed decisions.
Because I mean, you're giving me these play on words. You're giving me all of this stuff. I don't
speak the truth.
I don't feel you're speaking the truth to me.
I'm not working today at this present moment. I'm not working.
And you're not working. You don't have anything set for tomorrow.
No, I don't.
Right?
Nope, I don't.
You don't. Do you have anything set for next week?
No, I'm just anticipating things. You're right. I don't.
Do you understand what I'm saying?
Exactly.
I'm just gonna get you out of here. I'm gonna give you till March the 5th. You can either Zoom in or come in. I'm gonna give you till March the 5th to have the stuff paid off. All right?
Can I get a total of that?
What stood out was a single question at the end. With that moment, the defendant effectively undercut his own position. By asking it, he acknowledged that U.S. and Michigan laws apply, and that the court holds jurisdiction and judicial authority over this case. In practical terms, he recognized a legal relationship with the state that his earlier arguments tried to deny. For observers of these proceedings, it felt like a principled win for the rule of law. And based on past patterns with similar arguments, we may see this debate surface again. That closes today's coverage. Thanks for watching. If you found this useful, tap like, or dislike if you didn't, and share your thoughts in the comments. Subscribe with notifications on so you don't miss the next update.